What are the requirements with regard to notice if I want to relocate with my children? Is there a statutory basis for that? What's the opportunity for the other person to participate in that decision? Those are the questions that we're going to be looking at today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We're a family law firm located in Vienna, Virginia. I analyze challenges and find affordable solutions for families and their family law needs. Now, this comes up frequently especially with the more mobile society we have today, is that parents want to move, whether it's they're married to somebody else and want to move, they want to relocate for job, they want to go back and live with family or something like that. So, variety of reasons that people would want to move and, of course, take their children with them. However, moving the children then has, the secondary effect of what does it impact on the relationship with the other parent. So the whole body of law of relocation is fairly broad and extensive. We'll cover that in a whole separate video. But what we want to look at here is what's the statute with regard to notice for relocation. Now, the statute is Virginia Code 20-124.5, and it is required in any proceeding involving custody or visitation. The court shall include as a condition of any custody or visitation order a requirement that 30 days advance written notice be given to the court and to the other party by any party intending to relocate and any intended change of address unless the court, for good reason shown, orders otherwise. So the first thing is there has to be a custody order. If you have no custody order in effect, then there is no limitation as to what you do and no limitation with regard to notice. As we talked about back in our video where we were talking about COVID and custody visitation, there are potential criminal repercussions for violating a custody visitation order, which relocation could do. If you don't have the order, you can't violate the order. Also keep in mind that it's the Uniform Child Custody Jurisdiction Enforcement Act that comes into play here. And so we've had a number of cases where the parents and the children live here in Virginia. One parent takes the children, goes across the state line to Maryland, and then the person who stayed here in Virginia wants to file for divorce. And unfortunately, they find out that it's been 7 months that the parent relocated, and Virginia may have lost jurisdiction over child custody matters, although Virginia may have jurisdiction over, the divorce and property matters and things like that. So a number of jurisdictional issues there come up beyond the scope of today's discussion because we're going to focus on the 30-day relocation. So the proper course of action would be that if a parent wants to relocate, they contact the other parent and see if they cannot work out what a new custody and visitation schedule would be. If you were previously on 50-50 custody, maybe you could go and, given the distance, but once the parent relocates, someone would have primary physical custody and the other person would have visitation. You can work out and ensure that everybody's going to cooperate with regard to the new schools, the new travel, and all that sort of stuff. So again, ideal circumstance, work it out in advance. If for any number of reasons it seems like people choose not to work that out in advance, then the next course of action would be they simply provide their 30 days notice and go. The risk there is that the other parent that doesn't relocate it then has 30 days before the children move, assuming that the notice is accurate, to file an injunction to stop the relocation of the children. So you go down to court, you say, Judge, we can resolve the merits of the relocation on a later date, but until that time, I want the children kept here in Virginia until we have an opportunity for a full hearing on whether or not the children move to a new state, a new school district, and all that kind of stuff. So that's where the conflict comes in. And that's kind of the other option is, the parent doesn't provide the notice, and because it is in a court order, the consequence to that is there would be a violation of the court order, so you could look at a rule to show cause or some sort of contempt action on that. So something to consider if you are intending to relocate, especially with the beginning of the summer. Lots of families move during the summertime between the school year. But if you have that existing custody order, make sure you check that, because almost certainly there's the paragraph required by Virginia Code 20-124.5 that says you have to give the other parent and the court 30 days advance notice of the relocation. Ideally, work out the details in advance. There could be a circumstance where you relocate and you're at a different location, but you can still keep the same, visitation and parenting plan that would have less of an impact at that point. So just make sure you comply with the orders, and to the extent possible, work out and solve problems for the benefit of your children directly without having a judge do it for you.